questions to go over. Hello, everybody. Chuck Cook here, Cook Baxter, Louis Nasser. Chuck, he's got the Cook Baxter's logo in the corner. Sharp, very, very nice there. Well,
did that on purpose, boss.
Awesome. I need to do that in mine. James Hollis from Greg Siskin's firm, as Lily is down there trying to show I'm here. So Lily from Greg, because Greg is biking across Iowa. And Greg was trying to tell me that Iowa is full of hills. I don't know what part of Iowa he is biking across.
I think he's comparing it to Memphis.
Yeah, not the part that I've driven across way too many times. We've got Jeff Joseph and Sushi in the background. There he is. And Aaron went to go answer the door as he was getting on. It's like a little ding-dong. So great to be with you. It's great to see Jeff back, who looks extraordinarily relaxed after a, I'm sure, brutal vacation. This terrible vacation. Yeah. Welcome back, Jeff. It's great to see your smiling face.
I'm ready to get back to work.
Well, you missed all the fun last week, and I should have made you come down from Massachusetts to DC.
I listened in. So
hopefully you liked it.
I did. I thought it was interminably long, but.
Well, you thought it was long on the phone. You should have been in the courtroom.
Right.
It was like, are we ever going to end this? And here's the thing. I bought a 5 o'clock ticket because it was by the time the judge set the hearing, there was literally no other flights except the 6:30 through Detroit back to Atlanta instead of a direct flight. And at 5:35, I don't know if you heard, I even asked, Judge, can I go? Can I go? What are we talking about here? So when Aaron comes on, we're going to talk a little bit about the filing that we had last week on the status of the plaintiffs, the standing issue. One of the things that the government brought up, and this is, I think it's kind of a ridiculous point personally. Well, just because they had standing 3 months ago when they filed doesn't mean they have standing now. Like, all of a sudden, did you magically adjudicate 1,000 DV cases that you didn't tell anybody about? I sarcastically did not say that, by the way. So I think I give myself a pat on the back for reducing the sarcasm in the hearing. But we had to we put 5 or 6 individuals who had really compelling stories about the delay, including at least one person who was documentarily qualified in July of 2020. Who has not been set for an interview. That's just completely out. This idea that we're interviewing people in order is what a bunch of malarkey. And to quote President Biden, everybody's going, what is malarkey? They're going through, look up malarkey. What is malarkey? One of those great American words that nobody uses anymore except people with white hair like me. So we filed that on Friday. The government has until this Friday to claim that we don't have standing, which is just a nothing burger. All right. By the way, I did talk today with one of the government counsel, not the lead counsel, one of the government counsel, and I don't think they're expecting to win that case. I will just tell you, I don't think it's something that's on the top of their probably going to happen agenda. But the big question, Jeff, is when will the judge rule?
Well, let me just get out my crystal ball and glaze.
I need to get a magic 8-ball. I'm going to get a magic 8-ball and just look at my magic 8-ball.
I kind of, based on his questions, right? His questions were very good about what he wanted us to address, like standing, and I think he's ready to rule. He wants us to address some minor particular issues, and then I think he'll give us a decision. So
I agree. I think he's mostly written his decision. I think he was putting a fine point on some of his decision, and I also do believe that the questions are designed to avoid a successful appeal. He wants to win on it. If there's a government appeal, if there is, because remember they didn't appeal they appealed the Gomez case and then stopped appealing it. I'm not sure they're going to appeal. They might appeal the case, but I'm not sure they're going to fight it all the way through. So I think he's just trying to cross all his I's and dot all his T's here. So that's the response that Aaron put together. It was a great job. We did send it out to all the GO plaintiffs Right, Aaron? We got an email out to all the Go plaintiffs today, the copy of the redacted response. We wanted to make sure names and case numbers were taken out, but you'll see some compelling cases. And Aaron, there was a crazy question somebody sent you about that earlier, wasn't there?
Yeah, I think I've actually gotten it from a few people, and it's basically been, this is the one you're talking about, Chuck. It's people concerned that they might not be getting the same amount of relief because they're not specifically named in this little standing filing. And people don't need to be concerned about that. Judge Mehta is not going to limit the relief to people who were mentioned in this standing filing. And he specifically asked for at least one plaintiff. So he's not looking, he just needs to make sure that he has a plaintiff as a hook that has standing to make sure the whole case can go forward. But you're not at any advantage for being named here. You're not at any disadvantage if we didn't use your declaration. There's lots of people who prepared declarations and gave us information that was really helpful. We couldn't use it all because we only had 10 pages and he really only wanted one plaintiff. And so we had to go through and select some. But thank you to everybody who responded and gave us declarations.
And Aaron, I think we used all 10 pages, didn't we?
Yeah, we did.
Never tell a lawyer he can take as much pages as he wants to write something, because that'll be forever. But please stop believing what you hear on the internet, all right, like Telegram. Listen to the lawyers. You're going to be okay. Now, Aaron, I also want to address with you because this came up at the end of our hearing, which was the class action filed in a completely related lawsuit, unrelated lawsuit, and an email that I had sent to those counsel which said, look, we haven't considered it. We're really, at this point, we don't think it's in our client's interest. And the judge even said that a decision in our case binds everybody. And that's it. I didn't hear a word back from them. And then all of a sudden, the government copies us on an email with their position. And I wrote back and said, look, we haven't been consulted on the parameters, which is true. We were not consulted on the parameters of the class. And then the email that I had sent was misrepresented in the filing in the Rosales case. I will tell you, a lot of people are not happy about that misrepresentation, but we'll probably deal with that separately with a separate filing just to put a fine point on it with the judge.
So how does that work? Because I'm sorry, because I was gone, I have to catch up with all the emails, but like we can submit. Oh, sorry.
For the banner so that folks who are following know what.
Oh, yes.
About.
Thank you. You know, this is why Lily is wildly invaluable for a lot of things, but one of those
is my contribution
is to remind us of Go. All right. So, Jeff, you're like, what happened? What is going on? Right.
Yeah. What we get a chance to object to being part of the class, right? I mean,
well, obviously nobody is forced into a class, right? Class actions are always voluntary. And as the judge noted in oral argument, well, if a decision in one case, it binds everybody. It's a universal decision. So you don't need to have a class. And his question was very prescient. Why did you file a class action when you already had separate cases pending on the exact same issue, and then specifically exclude the cases you filed in your class action? I thought that, the judge, like, why would you do that? And over my shoulder, I thought I heard, somebody say, I know why you did it. So there's no reason to have a class here. Now, is there a benefit to joining a class if you're already a named plaintiff in the Go case, where the relief will be for you as a named plaintiff, as opposed to one of 130,000 class members? Aaron, what do you think?
At this point, I don't see it. But what I've been telling people is, at this point, we don't see a reason. It's not a motion, first of all, in our case, the motion for class certification. We think that our pleadings, our arguments, and our plaintiffs' facts stand on their own to get our plaintiffs relief. And so at this point, we don't see it. Now, everything that comes in, if a class is certified or if it's on the brink of certification, we'll always be evaluating to make sure that we're trying to put our plaintiffs in the best situation. So we can't know exactly what's going to happen. But at this point, it's a separate matter and a separate case, and we'll evaluate things as they come.
Now, if you remember, we did file a class action on DV 2021 in the Annunziato case, but only as to the proclamation's validity as it applied to DV 2020. And of course, all those plaintiffs now migrated over to Go, where we decided it wasn't in our client's interest to file a class action because we could have easily done that. Go ahead, Jeff.
Well, I was going to say one of the reasons, not even on this case, but all cases that we sometimes don't file a class action is because of the concern for appeals, right? I mean, the government doesn't like nationwide injunctions. And so I think there's a likelier chance that they'll appeal and seek a stay of the judge's order if it's class-wide, if it's nationwide. So, I think if you're a named plaintiff, that's part of the reason why we chose to proceed like this with individual cases. But, that's one of the concerns I have, I guess, about, this sort of group class action idea is that I think the government has more motivation to appeal it.
I will tell you that there is no agreement on a class from the defendants in this case. If you read the Rosales submission, the joint submission, they're a mile apart. And at least one class definition I saw was the only class members would be those who are documentarily qualified. I saw that's floating around somewhere, which would be a nutty. That wouldn't even hit 55,000. I mean, that'd be a nutty class to have. So that's kind of where it is. We're not going to worry about the class. If we think it becomes important to you, we'll let you know. But I did ask Jeff when he thought what day and time Judge Maida was going to issue the decision. He deferred to you on the date and time of the Go decision.
Yeah, sure. I'll predict with exact accuracy.
We learned in the Annunziato case, do not predict. But again, we think it's a decision. It would likely come in early August. But because a couple of factors. One, remember the government said that they had scheduled 6,000 people for interviews for DV 2021 in August and September, which accounted for 11,000 people. So those 6,000 cases were 11,000 plus people. In September of 2020, they interviewed almost 7,000 in 3 weeks. So as I said in our argument, it's the judge, they could do double this. Clearly they could do double this if they really wanted to. I don't think they're going to. I don't think they're going to add a whole lot of people at this point. People have been contacted. For example, Nepal just opened up. One of our plaintiffs got skipped who was documentarily qualified. I mean, there's going to be a lot of that stuff going on. A lot of other plaintiffs have been scheduled. Several plaintiffs have been given their green card, been given the interview and been approved. But the key to this whole thing, and it's always been reserving the numbers, particularly as it applied to our plaintiffs. That's always been it, because it's been quite clear that the Department of State simply is not going to make any effort to adjudicate enough cases to comply with the numbers for this year. That's been the case. So it's the reservation, and their kind of crazy proposal that they would not have a DV 2023 so they could do all these cases over the next couple of years, also wildly unacceptable. Wildly unacceptable. The judges, first of all, it's illegal. I mean, that would be a great lawsuit. And second, it's not going to happen. It's not going to happen. So
I did get my first inquiry from DV 2022 today, wondering if we're filing a DV 2022 lawsuit.
So I did. We have a client who won DV 2020, DV 2021, and DV 2022. We have a client that won 3 years in a row and hasn't gotten a green card in any of them yet. That is, I mean, I don't know who that guy is, but when he gets here, he's going to be buying me lottery tickets every day because that's the luckiest man on the planet right there. So there we go. And we don't have any news on what are they doing for Moscow? Don't know. What are they doing for Kabul? Don't know. What are they doing for Baghdad? I have no idea. What are they doing for Tehran? Yeah, this Department of State is silent, is absolutely silent on this stuff. So we don't have any more news for you than that. Now, once there's an order, once we have the order, yeah, we'll be all over all these issues. But we have to, once they're told you need to do this, then we can begin talking about them for our individual plaintiffs as we go forward. Okay? Same, by the way, on Gomez, Acker, 2020. You heard Cleveland Welton did a great job doing the final cherry on top of the whipped cream on top of the sundae.
That dude is so smart.
Yeah, he's scary smart. He's scary smart. It was funny. You couldn't see the video, but he was on video. He wasn't in the courtroom with us, and we were arguing, and he was on the video, and all of a sudden he was gone. We looked down, and he's gone. It's just him. It's just an empty desk. And for like 20 minutes, he's gone. Now, I think he had a headset on so you could see, but it's just weird, very disconcerting that you think he's listening to what's going on. He's just gone. So, but yeah, he did a great argument. Judge is obviously going to grant that case, and hopefully he'll grant more numbers. I mean, that's really the key for a lot of these plaintiffs. All right. Let's kind of go through the cases, talk about where we are. Basically, there's a lot of cases where we're just waiting. First one is K1 London. I'll just give Lily, because we haven't heard from Lily yet, other than to tell us to turn on the banners. We're still within the 60 days, aren't we, Lily?
We are beginning of September, so we don't expect to hear from the government for another couple of weeks, although it'd be nice if they want to call us up and
yeah, I will tell you that they haven't even assigned anybody to that case yet.
Nope.
So I don't expect there to be to hear anything on that for a while. Although they continue taking a quick back over to Milligan, they are interviewing a lot of London people. A lot. We don't have Greg here with us. I don't know if James has access, really has access to the Milligan list, but we've gotten a lot of approvals. And that was a big chunk of our Milligan cases in round 2 and round 3 were. So they are definitely processing those at, pretty high numbers. So let's keep the faith there. Now, have you heard anything separately, Lily, about London itself, about their general operations?
Not since the last time that we spoke. I think it was it last week or 2 weeks ago that we shared some information that one of our plaintiffs had sent us about how, so much of the space in the consulate was not being used when this person went into an interview, and that folks were chatting around without masks on, the consular staff. So I haven't heard much specifics since then.
All right. So
I remember we had
shape
heard
there,
from
then.
folks who know a little bit about the inner workings of consulates that August is often a time that a lot of folks take vacation, and that there's some turnover with new staff to old staff. So, with new folks coming in and other folks rotating out. So it might be that August is a slow month for reasons. In addition,
well, we can only hope that they eventually get this stuff done, right?
Yep,
so
they need to make a plan. They can't just sit on.
And in the Milligan case, how are we doing, Jeff? I think we're doing pretty good in Milligan.
Yeah, also just waiting. Case has been fully briefed on the motion to dismiss. So now we just wait for the judge's decision on Milligan.
I'm looking at the docket report, Jeff, of the Milligan case, which is very long, by the way. And the government filed some supplemental authority almost actually over a month ago. Right. So it's actually been pending. The reply was June 17th. And a lot of people asked us, what is the judge waiting on? You want to kind of address that with these judges? What are they waiting on?
I mean, if we look at the Milligan case specifically, right, the judge has already ruled that, refusal to issue visas based on a proclamation is unlawful. That ruling has not changed. It's still out there. So the only thing really that's still out there that's ripe is this mandamus issue, right? And one of the things that I think that the government has gotten really stuck on is that, these delays are not unreasonable because of COVID, right? COVID trumps everything. And I think Judge Mehta in the Go argument really honed in on why that argument isn't sufficient, because it only focuses on the unreasonable delay portion of the APA claim and not on the unlawful withholding of adjudication portion of the claim. So, I think that really there's no reason for the judges to be waiting any longer. If they're waiting to see if cases move, I think the evidence is sufficient to show that the consulates are simply withholding adjudication. Sure, London is moving, but there are certain consulates, Manila and Rio, that are part of our case in Milligan that are just not moving. And so I honestly don't know what the judge is waiting for at this point, because to me, it's a clear case of unlawful withholding of adjudication.
So we'll see. I mean, it's part of the problem is judges are very busy. When we were in DC last Monday, in the courthouse, the room next to us, the courtroom next to us, was the site of the first plea agreement from one of the insurrectionists on January 6th. And they filed like 500 of those cases. They're all in DC. And so I think there's only 20 judges. So they all have like 30, 40, 50 of these criminal cases that are popping quick through there. So I know that, and even Judge Maida even said when he was scheduling argument a couple months ago, look, my August is booked. So and I will tell you, it's summertime, and a lot of judges, they take vacation just like you and I take vacations. And if you're in DC, the best time to take a vacation is July and August. So also July is when the clerks rotate in the judicial offices, right, Lily? Clerks rotate. So new clerks come in, end of June they leave, new ones come in, and it takes a while to get back up to speed. So there we are on that one. I want to talk about K1 Rio. We are fully briefed in that case. And that was fully briefed as of the 16th. That's only been 10 days. That is Judge Cooper in DC. And we're waiting to hear what Judge Cooper has to say about this. He has not ruled on any cases that I've been involved in, so I'm unfamiliar with how he might rule. But I think we're going to see a lot. He's going to look, obviously, at Judge Boasberg's decision in Milligan and the decisions in Young and the decisions in Tate, as well as that in Go, and say, okay, well, you got to adjudicate these cases. I mean, you really got to do it. So anybody want to add anything on Rio at this point? No? Nice and quiet. Well, Walid is super quiet in the background there. He's waiting for his moment in the sun. We've got Manila. Where are we in the Manila case? Want to jump in here? Aaron?
We're fully briefed and waiting on a government decision, and I actually started getting some good news with the plaintiff updates in the last week or so. A number of you have been scheduled for interviews in August, so I still have to spend a little bit of time with the data and see if there's any pattern. I'm guessing that y'all in your Facebook group have already done this analysis, and you probably know better than I have what pattern there is, if any. But I've had several of you say that you have interviews coming up, so congratulations. And that seems to not only be people who have requested expedite. The first few interviews that we saw were folks who had requested expedite with urgent humanitarian situations, and I think one person who was a healthcare worker, the beneficiary. And several of the updates that I've received, at least they haven't said to me that they specifically requested an update. So, that they specifically requested an expedite. So I hope that means that the lawsuit is having some effect, that they're taking notice, and I hope that's good news. I know the folks of Milligan Round 2 Manila are hearing this and saying, what? Where are our interviews? I know at least one of those folks had an interview set. James, do we know if there are any other of the Milligan Round 2? I'm sorry, I put James on the spot. Does anyone else know if any of the other Milligan Round 2 Manila folks have?
I don't. I haven't seen any from the Round 2 in Milligan. But I mean, maybe it's that delightful video that the consul general put out there that said, yes, we're going to work on these cases, but eventually we'll get to everybody. Have a nice day. Jeff, you may have missed that video from the consul general of Manila. It was quite the 1 minute and 36 seconds of joyous bliss as she celebrated the fact that we would be interviewing people again.
We said we believe it when we see it, and we're starting to see it. So hopefully more of the same. Keep sending me your updates.
So in Ponomarenko, which is the Moscow case, of course, the separate issue in Moscow is that they don't have a consulate to go to. Just so that you know, we did give the government an extra week to respond to the complaint. That's why it's over 60 days. That was a conscious decision by me to cut the government just a little bit of a break. I mean, sometimes it pays not to be a jerk. And the government counsel in this case is the same government counsel we have in several cases. He was actually in oral argument with us last Monday, and this was due. I mean, his motion to dismiss or answer was due. And, I'm not going to say no to Joe. I just wasn't in that context. So I think it was a wise thing to do. But his response is due tomorrow. So pay attention. Ponomarenko, Moscow, let's see what the government does. Will they file an answer? Will they file a motion to dismiss? Will they ask for more time to say we're moving everybody to a different consulate? We'll see. One thing we do know is nobody's getting interviewed in Moscow. I mean, that's set in stone.
Well, and Chuck, just as like a little bit of an update, some cases that have been in Warsaw have been interviewed, have been issued. A month or so ago, we saw sort of the final folks going through Moscow. But yeah, we're all very interested to see what happens tomorrow with the response from the government, because they really do need to find a solution here.
We're looking forward to see how that comes out. Now on the K1 Cairo and family-based IR Cairo, as far as we know, everybody has been sent to all the K1s were sent to the consulate. Lily, was that last week or 2 weeks ago? I know it was sent in batch. And we know that all the IR CRs were sent to the consulate. I will tell you this. We used Cairo in the oral argument last week on DVs because they had already issued, as of the end of June, as many family-based cases as they had issued all of 2019, not last year, 2019, while they had issued essentially no DV cases. So it's clear that Cairo is doing interviews for K1s. And Cairo, we'd love to hear from you. If you've gotten an appointment notice now they sent the file over, that would be really great to know. Any of you guys want to add anything on that? No, they're all quiet tonight.
I was just going to say, Chuck, it's almost like they're trying to do a policy from the prior administration, and it's working.
Today, we can't really talk. We can't talk without saying about the travel bans themselves. The Schengen ban. Remember, it was yesterday when Prime Minister Merkel came over from Germany and asked President Biden, "Oh, Joe, please get rid of the travel ban." "Oh, we'll look into that." And what happened today? Does anybody know what happened today? Yeah, we're not lifting the travel ban. Sorry, Schengen ban staying in place. Who called that? Everybody raise their hand. Who called that? Who called that? There's no way Joe Biden is lifting any travel bans while COVID still exists. He's not going to do it. Joe ultimately is a politician. He's got a 65% approval rating on how he's handling COVID. He's not going to jeopardize that by lifting the travel bans. As stupid as they may be, he is not going to do it. He's not going to do it. So I had somebody call me today that said they were actually one of our O1s who got the visa but didn't apply for an NIE. And they're like, well, it was yesterday. Oh, I'm waiting for the Joe to lift the ban. I said, Joe's not lifting the ban. Today he doesn't lift the ban. She said, what do I do? I said, get on a plane to Mexico. Or ask for an NIE. You have to do one or the other because your TikTok, your visa's running out. Aaron, I want to talk about Annunziato for a second because we had a decision, didn't we?
Yeah, we did. Last week, that was Friday, the judge dismissed the case, granted the government's motion to dismiss, and that was about, I think we counted it as 18 remaining cases, unique plaintiffs, and it was certainly disappointing for them. What the judge said was he was not going to allow the case to be amended to be an unreasonable delay case when it started as a challenge to the proclamation 10014. And basically, just like he said at one of the last status conferences, he said, well, why don't you just refile? And so now that's what we're talking about, whether we're just going to refile and be right back in front of him.
So we're going to be in touch with the Annunziato plaintiffs, aren't we?
We are, and there's I think it's actually down to 16 now. We've had a couple get their visas issued in the last week, which is great for them. So I don't know how many are up for doing this again, but if people are up for it, Chuck and I were talking. We would love to be back in front of Judge Seaborg next week, saying, "Hey, here we are. This issue's not going away."
Oddly enough, we have a complaint ready to go. Oddly enough, it's right there. He said a couple of things that I believe are inaccurate in his decision. One, he said this: it would be imprudent to bar the visa ban when the Department of State has quote, already taken steps to minimize the proclamation's lasting effects. He said, noting that the department directed its overseas consulates to process visa applications without regard to the ban and to reconsider all visa refusals under the ban. What? Wait, what magic place did this language come from? That is not reality.
Uh-huh.
So actually, I think we're going to amend that complaint to say, Judge, by the way, you said this previously, and this is not true. It's just literally not true. So, we'll be in touch later this week with the remaining Nunziato plaintiffs. So stay tuned. Stay tuned. In any event, that was great work, and we won the case. All right. Ultimately, having that oral argument, which I can assure you, senior leadership in the Biden administration was well aware of in December, end of November, early December. They were well aware of that case. And there's no doubt that played a major part in Biden overturning that decision. They did not want to lose that case. They were going to lose that case. So I'm pretty happy with that and how that coming out. A couple other things. We want to talk about the H-1B lottery case. So Waleed is here. Waleed is working on this case diligently. Waleed, where are we?
So we had our PI drafted late last week, and then we got it out to the Immigration Brain Trust. That includes everyone here and some others. Some big immigration brains put their eyes on this and gave us their feedback, how to strengthen it, how to make it stronger, strengthen our claims, and that's what we did over the weekend. So we've got a much more polished, much sharper draft that is ready to go. Just waiting on some communication, some mandatory communication that we have to have with the government before we file a motion like this. And once we get that okay, we hit the button and then it's off to the races.
So the way the rules work that Waleed referenced this is before you file a preliminary injunction, which by the way is a request for the judge to expedite the case, expedite his decision, because somebody will suffer in a way that can't be repaired. So in order to file that, you first have to call, in this case, the government. Well, of course, the government had not appeared in the case. I mean, we filed it weeks ago, had not appeared in the case. Now, so I notified the government lawyer that we have the head lawyer, the head guy for the Department of Justice in D.C. and said, hey, we're going to file this. And we had communication with him previously where he'd agreed to let us make a slight amendment to the complaint to add a couple people to it. And so he said, here's the lawyer. Well, the lawyer is not Joe, but one of the other lawyers that argued the case last week in D.C. So I got to meet him. I know who he is. Smart guy, good guy. So he called me, he emailed me, I called him back. I said, hey, we're going to file this preliminary injunction. He said, I don't even have the complaint. I said, I'll get you the complaint. And he said, what's the emergency? I said, well, the government's going to have a secondary lottery on the H-1Bs. He said, this is the funny part. You know, the government doesn't have to issue all 85,000 H-1Bs. Really? Really? I can't wait to argue that. Let's assume they do have to issue 85,000. They only notified 87,000 people. Waleed, they won the lottery.
87,500 people is how many were selected in the first round. Last year, 122,000 were selected in the first round, and we still needed a second lottery to fill those numbers because of the duplicate registrations. I mean, this duplicate registration issue has been happening since the new rules came out in 2019, and even last year, given the amount of petitions that are denied or withdrawn or whatever, they still selected 122,000, and I think in the second lottery they selected 18,000. So this year, by selecting 87,000,
plus the denial rate, we don't know what this year's denial rate is.
Yeah, who knows how many spots are still out there?
No. So
who's our judge in this one? I forget.
McFadden.
Judge McFadden. Judge McFadden is the one that issued that really bad decision in the EB5 case. But I'm not sad about Judge McFadden. I think this is a very different kind of case. This is not a delay case. This is a look at the language of the Administrative Procedures Act and how immigration does lotteries, and ignoring comments that actually create a deal field fraud. And one of our plaintiffs emailed us this really great. Well, Jeff, was that from Facebook or Instagram or?
It was from Reddit, I believe.
Reddit.
Yeah.
You know, hey everybody, you should file multiple applications. Immigration doesn't care. That you can.
I think it was an advertisement for a company that does that. That says,
sign up with us and we'll put you in the lottery a zillion times. I mean,
it was crazy, and that will be right in the center of our argument. And I'm glad we delayed. So with the government lawyer said, look, he hadn't talked to his client yet. And again, we're not jerks. We're not here to punish the government. We want justice. We don't need to punish people. And so he asked for a day to talk to his client. I said, absolutely, go talk to your client, but you can confirm with them. He said, how do you know they're going to have a secondary lottery? Oh, I know. I know. It's called math, but I know. But you can ask your client. He says, oh, and it was a really good conversation. He was delightful to deal with. Good guy. And again, very smart. All these U.S. attorney guys and oil guys are smart. So I'll talk tomorrow afternoon, and then we're going to go ahead and file, unless the government backs off. Now, the government says we're not doing a secondary lottery. If they tell us that, we don't really have a preliminary injunction. We've got a motion for summary judgment, a different kind of thing. And of course, we can go ahead and file at that point. They're going to tell them they're going to have to do a secondary lottery. So that's the immediate harm to our clients as part of it. So
it should also be a news flash about when they're going to do the secondary lottery, because I know that a lot of people are worried and waiting for that. So
yeah, we've heard lots of rumors from reliable folks, and they're going to have to do it soon because I can't recall. Jeff, do you know how long people have to file the H-1B once they're notified? I have forgotten.
It's 90.
90 days?
Yeah.
It just disappeared from my brain. So that 90 days is now run, right?
Mm-hmm.
Yeah, it ran June 23rd or June 30th. That's what they did.
So I would expect soon. Keep in mind, the government's also on vacation in July and August. So there's nobody to count these numbers. So anyway, that's where we're going to be filing tomorrow with that, unless the government tells us. Because if in good faith they tell us there's no secondary lottery, we can't file that preliminary injunction. Because that's the immediate harm. The next harm is in March, and that's not immediate, and we can do a normal case. So that's kind of where we are. The last is the AOS EB delay litigation, which Joanne is not with us tonight. Hopefully, James, you have an update on that, where we are on getting ready to file that?
Yeah, we're preparing to file that this week. The main outstanding thing, and I don't want to put him on the spot, but Jeff, I hear you're about to be admitted in Maryland.
I am. On Friday, I'm getting admitted. So
that's wonderful news.
We have to file this case in Maryland because it is directly against USCIS. Normally, we file a lot of cases in DC because the government's located in DC, except the USCIS moved recently to Maryland, even though I have found out that the vast majority of their people do not work in Maryland, but it is their official headquarters. So you have to be admitted to the bar there, and Jeff will be admitted to the bar there on Friday. Now, Jeff, you have to fly there, don't you?
No, usually you do, but they're allowing remote swearing in.
Because nothing's better than flying into BWI in August. So that will be the moment Jeff is admitted, we'll file it. So it also gives us time to polish up. We have some great facts from you folks, and also we will have month end July numbers. And when I put a little something on this last week, it's really stunning that June, the government issues quarterly reports, and the quarterly report ends in, for example, would be end of December, January 31, June 30, but they don't come out for a month. So the most recent quarterly report we have is March, when they'd only adjudicated 14,000 EB cases, 14,000 out of what did we count last week? 250,000 that were available. I mean, do you think? I mean, all I asked last week, have you all gotten a rash of EB approval notices for adjustments? I've got way more individual hearing cancellations in immigration court than I've gotten adjustments approved, and we have plenty. We have hundreds pending. So I don't think the numbers are going to be any bigger. Maybe 20, 25, 30,000 the end of June. So now they're sitting on over 200,000 cases, and nothing's happening now. What are they going to magically do? 100,000 cases in August, September? No. So this is a big deal, and so having those numbers will actually be really helpful.
And Chuck, can you go over what the sort of next steps are after we file that? Are we going to do a PI in that as well?
Well, you know, the PI is an interesting thing in this context. I think we have to file a PI because if we don't, we won't have reserved, because it's all about reserving these numbers, right? We will not have reserved the visas for next year within the fiscal year. And I don't think we have any choice. That's the immediate harm, that these numbers will waste if we don't file the application. So the plan is within 2 weeks of filing the complaint to file the preliminary injunction. So let's say the complaint is filed on the 30th. That's Friday, right? Am I doing the math right? I think the 30th or 31st, Friday or Saturday. Within 10 days, 14 days to file the preliminary injunction. And again, work with the government so that we have a hearing on the preliminary injunction sometime in early September, because this is not about adjudicating everybody by the end of the month. This is really about saving these numbers. And that's, you know, obviously some people will be adjudicated, but it's a question of saving the numbers. And so the time frame is file the complaint by Friday, file a preliminary injunction, which then starts a clock. What would you say, Jeff? A 45-day clock before a hearing, something like that? Jeff, you're muted.
I think the government has 21 days to respond.
Right.
And then the judge sets it. I forget what the timing is, but I think it's in the rules what the judge.
Yeah, I don't think we get a reply. We have to look at the local rules in Maryland, but we don't get a reply brief. It's boom, boom, and you have a hearing.
It's a reply brief but it's by leave of the court.
Right. So we'll file. It should be. We'll see what happens. I mean, literally, there's nothing to lose, and we have the world to gain. Because remember, we did the math as well for next year. And they should have another 250,000 EB cases. So 500,000 EB cases, and they only have, now this is interesting, they only have 320,000 pending EB adjustments completely. That's everybody. That's even all the EB5. That's from their numbers from March. So they can wipe out the entire EB backlog in every category and still have 150,000 visas left over. Why aren't they doing this? I mean, there's obviously politics involved here, right? It's obviously politics. So there we go. We have some questions here. And I just saw your chat notice, Lily. Sorry about that. James Sherwood, Kinsley, K1 in London should be expecting different court's ruling. How did I forget about Kinsley? Kinsley is also pending, right? I mean, Kinsley is fully briefed, and we're just waiting on the judge.
And I think, James, I know you've asked this question before, and I think what he wants to know is the same question we've gotten from a number of folks who are Kinsley K1 plaintiffs in London and then also joined the London suit. And we've answered this question a number of times back when we were first starting the London suit, but since folks are still asking it, we can address it again, which is basically what was the point of Kinsley, right? The point of Kinsley was that we got the State Department what we've already accomplished, which is we think that Kinsley got the State Department to exempt immediate relatives and K1s from the travel bans by issuing a blanket NIE so that your cases could be processed as usual. That didn't necessarily mean they were processed promptly, but it removed the travel ban as an obstacle for most of our plaintiffs. For the plaintiffs who are still subject to the travel ban, and for those of you who are not now, but who could be at any time if the department changes the policy, the point of Kinsley is that we are challenging directly the State Department's policy that they won't issue visas to folks who are subject to the travel bans, right? So for now, they're being nice and doing us the favor of saying, oh, we'll still help you K1s. But tomorrow they could say, nah, K1s are subject to the travel ban again. And then London could say, we don't want to issue K1s anymore, right? We are challenging that policy on its face, and we want a ruling from the judge saying a travel ban does not mean you can have a visa ban, and we're still waiting on the judge to make a decision. We briefed it. It's all in the judge's hands on that issue. So that's, I know folks are I think I'm still seeing some confusion about the difference between a mandamus, which is we're asking the government to, or we're asking the judge to tell the government, hurry up and do your job, versus Kinsley is not a mandamus. It's a challenge on the legal issue of, if you have a travel ban, that doesn't mean that you can stop issuing visas. So that's the issue that we're still fighting in Kinsley, and we're up.
And again, the reason there's no mandamus in Kinsley is because a lot of people hadn't been waiting that long. I mean, a mandamus is the government is taking an unreasonable amount of time to do a case. And as Judge McFadden ruled recently, 2 years is not unreasonable for a green card in an EB-5 context. I think that's a ridiculous statement, and there's lots of other cases that go the other way, but you can't file a mandamus if your K-1's been pending for 3 months. I mean, that's not, it's not, if that's all you're filing on, that's not going to do it. So that's where we are. Mizi, we already commented on Go. We got that. CCDD, that's a very creative name. Status H-1B, we already talked about that. Jason Mullins, middle of round 2, get relief. The damn embassy. This is not just an embassy now. It's a damned embassy.
That's fair.
We have, I don't know how Delta is in other parts of the world. And I know some countries have Lambda, some have Gamma. But Delta is wreaking havoc in unvaccinated parts of the United States, unfortunately. And I would imagine it's probably spreading its way around the world as well. Terrible kind of thing.
I thought you were talking about the airline for a second.
No, no.
Like, what are we doing?
No, I'm a diamond medallion. I love Delta.
Yeah, you're Atlanta. You got to be.
What are the options for Iranians that choose Turkey and are documentarily qualified to get in with a very low number? Again, if you're our plaintiff, I think they're excellent because we're reserving your numbers if necessary. And again, we don't have the ability to really even negotiate with state on stuff like this until there's an order. Once there's an order, we're going to have lots of conversations with our friends at the Department of State about these cases. Because we can go back to the judge. We want a status conference. We want to talk about what's going on, and they can explain to the judge why Iranians who have been barred for 4 years are still being jerked around by the consulates. All right. Montreal. Oh, this also came up in oral argument. Judge, Montreal. I think it kind of surprised Montreal. Yeah, Montreal is just not issuing any visas to anybody. I've got, by the way, a family-based client who was interviewed in June on a like his mom sponsored him 15 years ago, and they said, "Hey, you're approved. Send us your passport." 3 weeks ago,
Still his passport.
And they haven't returned his passport. It's just, he called them and said, "Yeah, we have." Here's what they said: "We have to print your visa." Okay, go to the machine in your office and print the damn visa. How hard is that? Kind of crazy. Again, when you are, if you're emailing the consulate, they may or may not respond. But just again, a piece of advice for all the Go people. If you don't have your DS-260 done, you're toast. All right, you're gone. If you haven't emailed your documents to the KCC, you're probably going to have a big problem getting your visa. I'm not really worried about you being documentarily qualified as long as your documents are at the KCC. And when you're emailing, if you have been DQ'd, which is a hard thing for me to say because it means disqualified in the U.S. as of being documentarily qualified in the EB world, then you should be emailing both the KCC and the consulate in the same email saying, "Please transfer my case, please request my case." Okay? All right. Let's see. Marina updated us. The cases have arrived, not a single interview slot, although somebody did email me something from the embassy in Dubai that was like, "Hey, Saturday, August, whatever, is K visa day. Sign up, F1 visa day. Sign up for your F1 visas." It's really, there's a tone deafness at the consulates is all I can tell. Let's see. Will the judge be able to watch a live feed? If there's a hearing on any case, you will always be able to listen to it, but you probably won't be able to see it because federal courts don't allow cameras in the courtroom. And you didn't miss much with Judge Maida, because the view of Judge Maida is from a ceiling camera in the back of the room, pointed down on him, kind of a godlike view of this 40-foot marble wall and a little tiny judge sitting in the middle of it. So it's not like you're seeing anything that you wouldn't necessarily be hearing. Let's see. For Ramirez, I know about the July 4th travel ban. By the way, somebody from the London case sent over the fireworks that the embassy in London put on for July 4th. Isn't that technically rubbing it in? I don't know. I don't know if that's just rubbing it in at that point. Daniel says, hi, Lily. Let's see. Yes, I was right about the travel ban. Biden is not lifting that thing. Well, the government has any opportunity to extend any other motions? I get. I mean, this is why I prefaced the Moscow stuff before. You know, it's a courtesy. I know from your position, it doesn't deserve courtesy, and it's just a personal lawyer-to-lawyer courtesy, but it's the only one. So,
also, the judge is going to give them continuance anyways. They always give the government continuances, so we just look like an ass if we object to it.
Yeah, I mean, we do this for a living. It's the right thing to do.
Well, let me add that having courtesy one way often leads to a good relationship, which gets courtesy the other way. And so when we're down the line saying, hey, can you check on this one particular plaintiff where there's something weird going on? Can you make a few inquiries for us? And they do it. That's because we have a good relationship.
There is no harm in you emailing the consulate and saying you're a Go plaintiff. All right, don't copy us, okay? Because you are, in fact, a Go plaintiff. They might reply and said, we don't care what kind of plaintiff you are. You don't get any special treatment. Puh. Okay, whatever. But you're welcome to do it. Welcome to do it. Will the judge postpone you guys? I know you worry about these things, but no, I don't think that's going to happen. Let's see. A lot of these questions we answered already. Should the EB pay? We don't need, Santosh, good question. We don't need any other declarations at this point. We'll let you know next Monday as we're preparing our preliminary injunction. If you've got a particularly harmful thing, we probably will want to hear about it. In K1s, the summary judgment, we would dismiss after a motion to dismiss is granted. But here's the deal. On the K1s, all the stuff's at the embassy. Judge will go, well, what do you want me to do? Or, I mean, it's there. So at this point, we're going to see what the embassy is going to do. It would be worth reaching out to government counsel, Jeff, Aaron, to see about those K1s in Egypt and the IRRs in Egypt to see, hey, we understand you did this. Thank you very much. Out of curiosity, when? Just out of curiosity. I mean, we can dismiss the case the moment these cases are scheduled. So I think that would make them happy. Sam said, he said that they go file CP. Look, everybody in every one of our Go plaintiffs is a consular processed case. If you're in the United States and you're a Go plaintiff or any other diversity applicant for DV 2021, you can file an adjustment here. We actually just got one approved that we filed about 60 days ago out of Tampa. But you better have really great local counsel, because if you're filing an adjustment after you've been here for 90 days on a tourist visa, or if you entered like on an H-1B, you can file it now. You have to, you're giving up your consular processing, and there's no guarantee immigration will issue it. So you might want to stick with the consular processing, because this way you're reserving the visas. Pen plaintiffs, if someone's sending out the copies of the government's motion to dismiss, I thought, Aaron, do you have, Greg was working on maybe James was on the website to post all this stuff. James, do you have an update on that?
I'm not sure that was me.
Lily, do you know anything about Greg's website stuff?
I certainly
We'll have an update next week, but I know we've sent out a lot of these things on this. Philip says he just received the email. There's no attachments of the redacted version. James, can you check that? You got a copy, didn't you, Aaron, of the email? Aaron, you're muted. Aaron's going to let us know if Aaron should have got a copy of it.
I should have gotten a copy of it, and Sorry, give me a minute. Come back to me.
Was it
All
on
right,
constant
great,
contact?
we'll do that.
Yeah.
Will the Go plaintiffs receive priority if the judge rules positive? What do you mean by priority? If you're not documentarily qualified, no. If you sent your documents in, no. You don't magically jump ahead if you're not following our instructions. If you are documentarily qualified, then we look at the context of all documentarily qualified people for that country, and we then communicate with the government to get these done. Again, last year in the Acker case, every single one of our plaintiffs was scheduled in those 3 weeks. Every single one. And we have an expectation that will happen. And that's why we reserve visas in case you're not. So this is for all of us, by the way. You are all the best lawyers. Liz also said nothing attached, Aaron. So we will resend it.
We may have to do it as a link to our secure file sharing service, so I can get that set up after this.
Thank you,
call if y'all don't
Lily.
have an
We'll
easy way to do it.
resend that out. Yeah, Amy said the same thing. So we're
We'll get that
still
fixed and resent.
okay. Well, let's see. Lots of questions here. Let's see. Sorry, Chris. I was looking at the wrong case. It is Judge Kelly. Judge Cooper is a different case. Sorry about that. Had the wrong one open on my case. 15 plaintiffs in Manila. Ramirez got interviews complete or scheduled. Non-plaintiffs scheduled to do. No one NVC, only an embassy. Okay. Let's see. A couple other things going on here. Is there a legal basis to deny the case based on expiration of EB-5? Okay, so the EB-5 case, again, we'll be clear. It's the EB-5 Fong case. And let me put that up. The Fong case for right now is in Washington, D.C., assigned to a judge. But there is no EB-5 program for regional centers. There's no program. So there's nothing for the judge to do. In fact, if the judge adjudicated the case today, he would probably just dismiss the case. So it is in our interest to hold the case in abeyance until the EB-5 case comes out, one. Two, a different lawyer sued in D.C. on EB-5, and he got creamed by the judge. That's the Liu case. Creamed by the judge. So we have to deal with that in Washington, D.C., but it makes no sense legally to deal with it until the EB-5 program comes back, which I believe it will. So that's kind of where we are. We've got just a few minutes left. There's a lot of questions here. We appreciate everybody listening and following along, and we just got some really great questions. Have we requested that all Go plaintiffs be documented? No, because that's not our job. That's your job. That's your job to get those documents in. It's your job to follow up with the KCC. Our job is to clear the way to make that happen and get the visas issued.
But I mean, in effect, we are requesting that because we're asking. So the question from Fuad is, if he's submitted the DS-260 and all the required documents, well, yeah, we're telling them to do their jobs, and that includes documentarily qualifying you and adjudicating your visas.
So there you go. On the EB adjustment, if folks filed in DV20 in 2020, they can't really say there's lengthy delay. Well, I love Jeff's answer to this. Jeff, how long is it appropriate to have immigration take for an adjustment of status application?
Well, if the case has been, first of all, the adjustment case has nothing to do with mandamus, right? I mean, we're not adding a mandamus claim.
Oh no, there's absolutely a mandamus claim, absolutely in the EB context. So
the bottom line is that it's not really necessarily a delay. What we're saying is by failing to adjudicate all those visas, it's unlawful. It's a withholding of adjudication. The statute makes it clear that they have to, issue those visas, and by not doing so, that's unlawful withholding of adjudication.
But did anybody remember last week, how long does it take immigration to adjudicate an adjustment of status application?
98 minutes.
Yeah.
So why do they take years?
Mm-hmm.
Because they choose not to.
Why did they take 6 months 5 years ago and now they take 24?
No. So what is reasonable depends. And it doesn't depend on how long the government says reasonable is. That cannot be any standard for all these cases. If you're paying $1,225 for somebody to spend 95 minutes adjudicating your application, keeping in mind that you're only allowed to file the adjustment if the USCIS says that this year we can adjudicate it, because the priority dates only move forward based on the USCIS saying we can do them this year. So reasonableness is within the fiscal year. So yes, it is long enough. I'm really excited about this oral argument in that case. We got some terrible people on here we need to block. I'll do that. Get that person out of here. I don't know who that is, but there's a lot of negative people out there. It's sad that they live in the world they live in. Let's go. Jeff, I'm going to leave this one to you, Jeff. Last question from Kyrie's Little Hearts. What will happen in DV 2022?
Well, I hope we don't have to sue. I hope that the resolution of these lawsuits will prompt the Department of State to pay more attention to diversity visa 2022. But I don't know. I anticipate we're going to be back in court again, filing another complaint in 2022, to be honest with you. I don't see that these backlogs going away.
Well, they seem like they were very focused and keen on it when they were at oral arguments, saying that they're preparing for 2022 now, so they clearly can't fix the problem for 2021 with the 2022 numbers.
Which is why they asked to postpone the DV 2022 lottery forever, which is, of course, illegal. But think about this. We will know on October 1st if they're interviewing DV 2022 people, right? So if you won the DV 2022 lottery, what should you be doing today? You should be filling out your DS-260. You should be proactively sending your documents to the KCC today, so that you can become like one of our plaintiffs, documentarily qualified in July of 2021, so that on October 1, you should be interviewed. So that's what's going to happen. Thank you, everybody. Everybody stay on the call for just a second afterwards. We're going to say goodbye to our viewers. Thank you very much for attending today. We'll see you next Monday night.